Mr. Hibbner, you may call the next case.
City of Knoxville, Tennessee versus Netflix Inc. et al.
Morning, Your Honors. Mr. Chief Justice, may it please the Court, Gregory Garr on behalf of defendant Netflix. With the Court's permission, I'd like to take 15 minutes of defendant's time. My colleague, Mr. G, who represents Hulu, will take 10 minutes of defendant's time, and then we'd like to reserve 5 minutes of time for rebuttal.
All right, thank you.
Thank you. Your Honors, this Court granted certification in this case to decide whether Netflix and Hulu are video service providers under the Tennessee Competitive Cable and Video Services Act. We respectfully submit that a plain meaning interpretation of the Act compels the conclusion that that question be answered in the negative. Most fundamentally, the Tennessee Act establishes a facilities-based scheme that rests on a basic bargain. In exchange for laying wires, cables, or facilities in the public's right-of-way, you must pay a franchise fee. Or you could think of it this way: if you dig or occupy the public rights-of-way, you must pay. The Act's provisions explicitly incorporate that bargain. For example, Sections 3038 and 305E2 make clear that the Certificate of Franchise Authority grants the holder the right to construct or maintain facilities in the public's right-of-way. And conversely, Section 306I explicitly states that the franchise fee is, quote, intended as a form of compensation for the provider's occupancy of the public's right-of-way. This quid pro quo lies at the heart of the Act and is critical to the formulation of the Act. And the Tennessee Advisory Commission on Intergovernmental Relations recognized this in this 2019 report.
Mr. Garr, what weight should we give to that report?
Your Honor, it's certainly not entitled to the weight of the text of the statute, which is what we rely on. I think it is informative, though, in terms of how the Act has been understood, particularly since the Tennessee Advisory Commission is made up of legislators as well as state and local officials, and those officials must actually vote on the contents of the report. So the fact that that report, which was requested by the legislature in reconsidering whether additional legislation was necessary, concluded unequivocally that video streaming services were not covered by the Act because people who were simply engaged in streaming content over the internet did not lay the infrastructure themselves, and so were not subject to this bargain. I think that that is noteworthy for this court. That report concluded that further legislation was unnecessary. In effect, plaintiffs are asking this court to engage in the legislation that the Tennessee Advisory Commission declined to by extending the Act's franchise fee requirement, which has always been limited to those who are actually occupying the public rights-of-ways, to those like Netflix and Hulu, who do not own, operate, construct, or in any way occupy any place in the public right-of-way.
But they do rely on those wires or lines or whatever that are on the public right-of-way, so people can access their product. And if those were not there, then Hulu would not be able, Netflix would not be able to broadcast to their subscribers.
Your Honor, that's true. Content is made available. Some of it goes through the wires, which are provided by third-party internet service providers. Some of it is wireless. But again, that does not make them a video service provider under the Act, because the Act does require this basic bargain, and it talks about the franchise fee being a form of compensation for the occupancy of the public rights of way, which Netflix and Hulu don't. And you have to think about the extreme results that would occur if this court adopted plaintiff's interpretation. Under their interpretation, anyone who streams or makes video content available over the internet is a walking video service provider, potentially subject to franchise fees, regardless of whether they have any connection to the public rights of way. So that would include a high school that streams streams football games over the internet, or a church that streams services over the internet, or this court itself, which is streaming this argument today over the internet. All of those providers, entities, would potentially be video service providers subject to franchise fees under the Tennessee Act, even though none of them has any connection to the actual public rights of way. They don't own, operate, or occupy any.
Definition of television programming, right?
That is one element, you're right, Your Honor, that's one element of the definition of video services.
Video services, just to clarify.
Well, Your Honor, certainly C-SPAN would cover governmental proceedings, so I'm not sure that would be that much of a stretch to say.
We're not
that-
charging for our services, so there'd be, the franchise fee would be there would be no argument about that, so there's no charge for C-SPAN for.
That's right, Your Honor, but again, I think this goes to the breadth of their interpretation. There would be, if this court is not charging a fee, then there would be no franchise fee that could be assessed. Nevertheless, the argument would be that you are a video service provider if you concluded that streaming governmental hearings over the internet was video programming, and that there was no requirement of any connection to an intrusion on the public rights of way. And again, this would apply to anyone. This would apply to someone who posted a TikTok video, which was later streamed over the internet. And the only interpretation that gets plaintiffs to that point is the notion, and Justice Lee, you raised it, that, well, somehow this content is still going through the wires and cables or over the wireless facilities, and so therefore, indirectly, they are video service providers. But again, that construction is explicitly contradicted by the terms of the Act, which make clear that the certificate of franchise authority is granted so that you can construct and maintain facilities on the public rights of way, and that the fees that we're talking about are intended as a form of compensation for the provider's occupancy of the public rights of way. That's in Section 306I, and I think that provision in itself explicitly forecloses plaintiff's construction of the Act.
Well, and I think that maybe answers in part the question that I had. I mean, in your opening, you urged the court to adopt a plain language interpretation of video service provider. But I mean, if we actually look at subsection 19, the definition of video service, I mean, the plain language that's used there is simply through wireline facilities. And you know, you're really asking us to read in additional language there to limit that term to through wireline facilities that, you know, the provider owns or operates. And, you know, that's just not there. So, you know, what do you think is the kind of best statutory evidence in the overall statutory scheme that supports the limiting construction that you're asking us to adopt?
Right, and so that language through wireline facilities obviously has to be read in context, and it's provisions that I mentioned. Section 303A, which defines the franchise, and that explicitly says that the franchise is granted to construct and operate a cable or video service provider's facilities within the public rights of way. Section 305E2 talks about the certificate of authority, and it says that it's a non-exclusive grant, I'm quoting, to construct, maintain, or operate facilities through, along, upon, over, or under any public rights of way. And Section 306I explicitly says that the franchise fee is intended as a form of compensation for the provider's occupancy of the public's rights of way. And I think all of those provide an unambiguous context for interpreting what the Act means when it says through wireline facilities. It means through the wireline facilities that the certificate of authority gives you the right to construct or maintain or operate in the public's rights of way. It does not extend to video streaming services like Netflix and Hulu, who indisputably do not own, operate, or control any facilities or infrastructure in the public's right of way. And of course, the Act's definition of video service in 303.19, as Justice Campbell noted, does include other components as well, one of which, as Judge Kirby noted, is that it must be video programming. And video programming is defined under the Act, Section 303.18, as programming that's, quote, comparable to that provided by a broadcast television statement.
I mean, isn't that definition a little, I mean, I have a hard time with that definition in that it's a bit circular, right? I mean, video programming is defined to include the term programming, which itself is undefined. So how are you interpreting the word programming?
Well, I think what we know from 303.18 is it has to be programming that's comparable to broadcast television programming. And I think Netflix in particular is fundamentally unlike broadcast television programming, and that it's available anywhere, at any time, at any amount or duration, whereas broadcast television programming, by definition, is scheduled and channelized, available on discrete channels.
Well, that assumes that programming, the term programming, is referring to sort of the presentation, the manner in which the content is presented. But if you look up programming in the dictionary, there are a couple of different definitions of programming, one of which is, I think, the way in which you were defining the term, but it can also be defined to refer to the content itself.
Right, but I do think, though, Your Honor, in 303.18, you have to give effect to the reference to broadcast television programming. So I think that has to be part of how you define video programming, because the legislature itself said it has to be comparable to that. And so it can't
But couldn't it be comparable in terms of the content rather than the presentation?
I don't think so, because then the test would be can you go on broadcast television and find anything that might be similar to the content that is provided over the internet? And that would be so broad as to make the definition meaningless. I think
that's called on demand, isn't it?
Well, Your Honor, Netflix's services are accessed. The content is available by users who can go on an app or their computer to call it up. But again, I mean, that is fundamentally unlike broadcast television. I mean, I'm certainly old enough to remember going to the channel, looking at the TV guide and flipping through it, and that was it. You didn't get to decide when you wanted to watch your show, how many episodes you wanted to watch, or what time. It's a completely different environment, and I think that that's the distinction that the legislature was drawing. And that makes perfect sense when you think about traditional cable TV operations, which is in the heartland of what the statute the legislature had in mind. Because
I don't want to tell you how to run your argument, but I would like to see you address the exception in subsection 19 for video programming of the public internet.
Thank you, Your Honor.
And if you're successful on your first argument, do we get to the exception?
You don't need to, Your Honor. We think that there are, multiple independent ways in which we win, but we do think that the exception is one of those.
All right.
And I think the exception itself is another indication that the legislature did not have in mind video streaming services, because the exception would apply to video services, assuming we're in the definition, the front side of the definition, that are made available for access over the internet. And that, I think, describes Netflix's operations, video programming, as well as Hulu's content as well.
Under that exception, how do we distinguish between, say, Netflix and Comcast?
Well, Your Honor, I mean, I think, first of all, you'd have to determine that they meet the definition of video service, so that they do include video programming, and they are, through the wirelines language that Justice Campbell and I talked about was applicable here, even though they don't have traditional operations. I mean, Comcast would be, through actual cables, and probably would
not just over the public.
Exactly, and so therefore you would invoke the exception there. But I think that the exception really perfectly encapsulates and covers video streaming services that are simply made available for access over the internet through third-party internet service providers who may or may not themselves operate facilities in the public rights of way. But the fundamental
Over internet available by satellite.
Exactly.
Okay.
Wireless, satellite, exactly. But the fundamental point that is not contested and is conceded in paragraphs 16 and 17 of plaintiff's complaint is that neither Netflix nor Hulu operates, maintains, or constructs any facilities in the public's rights of way. And for that reason alone, they are not subject to the Act's franchise fee requirements, and they are not video service providers under the Act. And so we would urge the court to answer the certified question in the negative.
One quick question. I read a number of the trial court orders. What other appellate decisions are out there on this issue?
Your Honor, there are several because they're piling up. I'd encourage you to look at the City of Lancaster decision just last month from the California, though that was from the California Superior Court, Your Honor, so that is now on appeal. But that held that Netflix and Hulu are not video service providers under similar law. Gwinnett County, Georgia Superior Court reached that conclusion as well.
And now, besides, and those are trial courts, right?
Right.
Any appellate courts have weighed in?
Not yet, Your Honor. We were just before the Ohio Supreme Court last month, so and a number of these are on appeal.
Right.
But of course, we think this court would be guided by the terms of the statute and reach the certified question. Thank you, Your Honors.
Thank you.
Chief Justice Page, and may it please the court, Victor G. on behalf of the respondent, Hulu, LLC. I want to pick up where Justice Campbell actually raised. I do think the answer to the certified question can be found in the definition of video service in the language that's contained in the statute at 303:19. The statute says that video service refers to the provision of video programming through wireline facilities located at least in part in the public rights of way without regard to delivery technology. Focus on that part first. I think the phrase is not just through wireline facilities, but the verb matters. It's the provision through wireline facilities. And the statute goes on to say without regard to how the delivery happens, without regard to delivery technology. That means the statutory focus is on the person who's providing the signal through the wireline facilities, the person who takes responsibility for delivering the signal through the facilities. That's the focus of the statute. Now, what does that have to do with this case? Well, as basically the city acknowledges in paragraph on page 21 of their brief. Quote, petitioners deliver their video services through subscribers' ISPs, which own and operate wireline facilities in public rights of way. The ISP acts in the role of a common carrier for petitioners' content. What does that mean? It means that provisioning, the delivery, the carrying of the signal through the wireline facilities is not done by Hulu or Netflix. It's done by the ISP. And that's why the terms of the statute don't apply just from that language itself to what we do. Any ambiguity is answered by just reading the terms of the franchise. In other words, the context of the statute. I submit, Your Honor, that you cannot interpret the franchise mandate separately from the franchise conferred. Otherwise, you result in anomalies or inconsistencies within the statute. And the franchise is specifically defined as authorization to construct and operate a video service provider's facility within the public rights of way. That's the definition. It makes no sense to apply the franchise mandate to anyone other than someone who needs to construct or operate a facility in the rights of way. Now, that's why that concession respondent's brief is so interesting, because they acknowledge that the wireline facilities in question here are owned and operated by the ISP, not by Hulu, not by Netflix. We don't have such facilities. If you stretch the statute to apply to us, even though we don't construct or operate any such facilities, you're basically requiring us, simply because we speak online, to acquire and seek a franchise and to pay for that franchise, even though we don't use the franchise, because the franchise is limited to those who construct or operate facilities.
Are you making the argument, I guess as I read the briefs, you are not making the argument that Netflix makes that they do not provide video programming, as that term is defined in the statute?
We certainly agree that video programming has a unique definition under federal law that does exclude our on-demand programming. We did not make that argument below or focus on it, Your Honor, because we don't think we need to get there. And it may involve facts that are not in the record. To us, it's clear that the statute is written in a way that doesn't really turn on the content of what we're providing. That would just raise a whole host of issues if we're trying to make distinctions based on the content of what we're distributing. Instead, the statute's focuses on whether or not we construct or operate facilities in the rights of way. A facilities-based approach has always been the way franchises have been interpreted, for this state for many, many years, and throughout the country, to avoid the constitutional problems that arise if we focus on content instead. And in here, I think there's even a bigger clue beyond the definition of the franchise that goes further, because it only authorizes the construction or operation of the video service provider's facilities. That's a weird quirk, because if we can be required to obtain a franchise because a subscriber might use someone else's facilities, it's odd to require us to obtain a franchise that only applies to our facilities if we have any. That's the kind of anomaly and inconsistency that gets created by plaintiff's claim here.
What, in your view, is the narrowest or narrower, if we're just considering, I guess, the two options of either the definition of video service or the exception? What is the narrower ground on which we could decide the case? I mean, so my concern is, I think this is an evolving area of technology. Any decision that we make in the interpretation of the statute could have unanticipated consequences or just unforeseeable consequences. So as between those two bases for, saying that the statute does not apply to Hulu and Netflix, which do you think presents the lesser risk of those sorts of consequences?
I actually think because the exclusion is written in the definition itself, I think they're both, frankly, equally narrow, because I think they're flip sides of the same coin. So turning to the exclusion, right, the legislature makes very clear when it says, whatever you think video service means, it excludes video programming that is provided as part of or via basically internet access service. Now, if you look at that, what does that tell us? It tells us that if the reason this video content is going through wireline facilities in the rights of way is because that's how someone's accessing the internet, it's excluded. That's the plain meaning of that provision, which works hand in hand with the scope of the provision in the first place, because it's focused on who's providing content through wires that are located in the private and the public rights of way. That language that is used, it's a little clunky, it's a little weird, but it appears in a lot of statutes. It appears in the federal statutes first and foremost, but it's adopted in many of these state statutes. And by the time it was adopted in Tennessee, there were already judicial opinions interpreting that language. Specifically, we cited cases like the MySpace opinion, and those cases cite to a Fifth Circuit opinion that had already construed that language pretty broadly. It basically said, based on all the courts, at least at that time, as of 2007 and before, I think the Fifth Circuit was in 2005, the court interpreted that language to say that encompasses almost any service that has a website, any service that provides access to content on the internet. That language was well understood to mean that, which is why when ITFA was amended by Congress, they had to change the language to limit it to ISPs in a narrower sense, to use new language. They kept a broad version and a narrow version. I submit that under existing, I would presume the legislature understood, I think this court usually follows the canon, that if there already was judicial construction of language, and that's how the legislature chose to use those words, you presume the legislature had in mind what the courts had said that language means. So what it says is, since Hulu is offering video content as part of its service, which enables people to access content over the public internet, we fall within that exclusion. Even if, as the city has suggested in some instances, that language is limited to ISPs, which I would submit that was not the case under the precedent at the time, we're still excluded because the only reason Hulu's content is going through any wires and any right of way is because it's part of however a subscriber happens to access the internet. It falls under that plain exclusion. And so that would ultimately answer your question. I think there is no narrower or broader grounds because both of it, I think, are flip sides of the exact same fact, which is conceded in respondent's brief that we don't own or operate wireline facilities. ISPs do. We are not the ones carrying the content through wireline facilities in the rights of way. It's the ISP that does that. Now, the fact that Justice Lee had mentioned that, look, certainly we rely, anyone who accesses the internet relies on wires and the infrastructure that has been created to access the internet. But that's paid for in a specific way. That's paid for by the people who install the wires and lay them in the ground. What this does is expand it by requiring, simply because we are distributing video content online, to suddenly have to pay on top of that. And that is not what the statute contemplated. There's no indication anywhere in the statute. And frankly, I think all the record indicates no one has ever suggested the statute should be applied to us simply because we distribute speech, expression, content over online wires.
So, Mr. G, if I'm bothered by the fact that you could not operate without those wires in the ground, your response to that is that a legislative body needs to amend the statute if that's what they want to do?
Well, first of all, remember, as a factual matter, whether or not we have to use the wireline facilities in a particular municipality depends on how their residents access the internet. It may involve wireline facilities maybe in other counties, depending on what the infrastructure is set up like, but it may not involve the wireline facilities of any particular municipality. That's a factual question.
Could be a cell signal, could be satellite.
Correct. And wherever they connect to the rest of the internet, maybe somewhere elsewhere in the state, it may be, who knows, right? That depends on how it's deployed. The statute, however, the reason it's written the way it is not to say that the cities don't have any recourse or any way. I mean, they are compensated for physical occupation of their public rights of way.
I know you're answering a question, but go ahead and wrap it up.
Yeah, but so I think it turns on if there actually is physical occupation. That's how the regime works. It isn't to leave municipalities uncompensated. So I'll reserve the balance for rebuttal.
Thank you.
Good morning, Your Honors. Chief Justice. May it please the Court, Justin Howell on behalf of the respondent, the City of Knoxville, Tennessee. The parties agree that this is a relatively straightforward case of statutory interpretation. What the parties disagree on is what the statute means and what the definition of video service means. The city quite simply contends that the definition of video service means what it says, that any entity that provides video programming through wireline facilities, like petitioners do, located in the public rights of way, regardless of the technology used, including internet protocol technology or any other technology, are subject to the requirements of the statute, including the requirement that they pay franchise fees to municipalities in the state of Tennessee, such as the City of Knoxville. The plain language of the word "through" is by way of, and it cannot be reasonably disputed that the petitioners provide their programming by way of wireline facilities located in the public rights of way.
But what about the customers, and this was just mentioned in an earlier statement, customers who connect via satellite dish, and we still have those in some areas. If I have a satellite dish, that doesn't involve the right-of-ways, and yet I've got a Netflix subscription or Hulu. Are you going to get a 5% franchise fee on that if we rule in your favor, even though
No.
I'm not connected to the local, to the?
No, Your Honor.
Knoxville?
So the statute expressly excludes satellite service. I think your question goes more to the calculation of gross revenues.
Yeah.
And so we believe that that it's the burden of petitioners to calculate the gross revenues that they receive through the provision of video programming using wireline facilities. And so if they want to provide that calculation to the cities in the state of Tennessee, as they're required to do under the Act, then they can exclude any subscribers that use only satellite internet connection in their calculation.
If the language of the statute so clearly covers your situation in your favor, why did it take so long? We had a case a while back under the liquor by the drink tax, where a statute had been in place for a long time, where the cities got their share of the proceeds of the liquor by the drink taxes. And at some point, 20, 25, 30 years after the statute was in place, county woke up and said, wait a minute, we're entitled to that money that the city is getting. And we started getting lawsuits all over the place from counties who were saying, our municipality should be paying us those taxes. This strikes me as similar, where suddenly municipalities are waking up and going, wait a minute, Netflix and Hulu and these other streaming services are clearly covered by it. But this statute's been in place since, what, 2008? And Knoxville is just now waking up and saying, why, we lane-laning. I mean, we decision in the liquor by the drink case. Doesn't that factor into our calculus here?
I think there's a couple reasons why it's just now coming to light now. One of the main reasons is because Hulu didn't exist in 2008 when the statute was written. Or I shouldn't say they didn't exist, their streaming service didn't exist. And Netflix's streaming service was in its infancy. It was still largely a video DVD subscription business. And as technology...
In the age of the internet, it's been a long time since they came into existence. And Knoxville's just now raising its hand and saying, why do we need a franchise fee?
Well, I think, Your Honor, it's only until recently that the service that the petitioners offer has reached the quality and level of programming where they are now competing directly with traditional cable companies. And Your Honor may have heard of the cord-cutting phenomenon is becoming more and more a situation where subscribers and residents of the cities are moving away from traditional cable providers and moving towards streaming services like Netflix and Hulu. And that is having a direct impact on the money that these municipalities need from these companies.
And isn't that a great argument to go to the legislature and have the legislature amend the statute?
Well, I don't think it's on us to have the statute amended. I think we're just asking this court to apply the plain language of the statute. And if Hulu and Netflix, who have billions of dollars, and I assume a lot of lobbyists want the statute or the legislature to change the statute, I believe it's on them for them to advocate to have the plain language.
What about the aspect of the Taser report that opposing counsel brings up, and the fact that the Taser certainly identified or recommended that there be no change in statute, and also took the position that it does not apply to entities such as Hulu and Netflix, and the legislature has not taken any action?
Yeah, well, I would first say that report obviously isn't binding on this court, but also the Taser report didn't interpret the meaning of the statute. It simply went on what Justice Kirby was saying, that it hadn't been applied factually to these companies prior to this point. And so I think the question of what they were asked to do and look at is much different than what we're asking the court to do, which is apply the plain language of the statute and find that they offer video service.
How the statute is it up to the state to determine whether a franchise fee is required?
It is not, Your Honor. Actually, the department is granted limited authority under the statute, and they do have power to investigate complaints against video service providers, but that right is in addition to all remedies under the law for the municipalities. And so the statute expressly states that municipalities have standing to pursue claims on behalf of their residents for franchise fees. And I submit to you that's why the district court chose not to certify that question, because that issue was fully briefed before the district court.
What law can you point to provide the remedy that you're seeking, which is declaratory judgment? I mean, what statute actually provides the cause of action?
We believe that the video service provider statute provides the cause of action, as I mentioned.
That you're pointing to this language that kind of preserves other remedies at law. I mean, what in the statute itself, I guess, provides you with the remedy that you're seeking?
Well, the statute certainly carves out a provision for municipalities to bring disputes with respect to compensation.
Well, is that under subsection 306, which allows a party to determine the correct amount of the franchise fee? Is that
Correct.
That subsection?
Correct, Your Honor. And in addition to the language that I mentioned earlier, and I recognize that section does speak to the ability to conduct an audit and determine whether or not the video service provider is underpaying. But we believe it would be nonsensical to conclude that the legislature intended a municipality to have a right to bring a case for underpayment of an entity that is actually complying with the plain language of the statute, but not provide the municipality the right to seek compensation for someone who is flouting the language of the act and not paying any franchise fees.
But under subsection 306, the only party who owes the franchise fee is one that is the holder of a state-issued certificate of franchise authority. So it seems like you're skipping a few steps. I mean, if you want us to rule that they have to pay this franchise fee, we'd have to first order them to apply for the franchise. We'd have to order the state to issue the certificate, and then they would owe a franchise fee. I don't see how we go straight from here to here. And isn't the Public Utility Commission's role to require a party to apply for a certificate of franchise authority if one is required?
Well, in addition, again, I'll go back to the standing language that I talked about earlier, as well as the language that says the municipality can file complaints with the Utilities Commission in addition to all other remedies under the law. And so I think all other remedies under the law is certainly the right to have a determination as to whether or not their video service providers in the first instance were required to have an application, because the Act puts the onus on the petitioners to apply for the video service franchise fee. It does not place the onus on the Director of Commerce to go out and investigate and determine every person that's potentially violating the terms of the Act.
I think my question may have inadvertently gotten us onto the issue of standing. Back to the certified question under subsection 303, subsection 19, I'd like you to address the public internet exception.
Sure, Your Honor. It's our position that that exception was intended to apply to ISPs, because if you look at the plain language of the exception, it says it applies to entities that provide their service solely as part of and via a service that provides access to content, information.
How does that make sense? I mean, if you look at the provision as a whole, how does that justify? I saw that argument and I just could not follow it. And I may be thick, definitely. So I'd like you to address in the context of the overall intent of the Act and the overall language in subsection 19, how that makes sense.
I think the overall structure of the Act was intended to apply to entities like traditional cable providers and petitioners that are in the business of solely providing video programming, which that part of language is important because their video programming is not part of a larger service like an ISP or maybe even another website that tangentially or incidentally offers.
99% they fit the exception. If it's 100% they don't. What? I mean, I'm just not getting it.
The other piece of the definition is access to information, content, email, or other services over the internet. Petitioners' services don't provide anything by way of access to any other content other than video programming, which is the sole service that they're offering.
It doesn't say and all these things. It says used to access content, information, electronic mail, or other services. So it's not conjunctive, it's disjunctive.
But I would argue, Your Honor, that they don't offer any other service other than video programming.
So what? How is that important? If they offer one of these things, if they offer content, which they do, I mean,
I'm not sure
how does this exception not fit?
I'm not sure content is synonymous with video programming. Video programming is separately defined. But I think the clear language of the statute was to not have this statute apply to internet service providers who do technically transmit video programming over their wires and cables, but it's part of a larger service that they offer, which does include content, information, email, etc. And so I think that is the intent of the legislature, which also goes towards the...
What particular language in that exception? Look at the language in subsection 19 and look at the language in the exception, in the latter part of that subsection, if you would, and tell me what particular language you're relying on to say that it does not apply to Netflix and Hulu.
So I'm relying on the phrase solely as part of. again, their video content or their video programming is not solely part of a larger service that quote, enables users to access content, information, electronic mail, or other services offered over the public internet. I would also point out, Your Honor, that if petitioner's reading of the statute is correct, that any video content offered over the internet is excluded, then the act will soon be rendered obsolete, because even entities like AT&T, Cox, Spectrum are all starting to move towards offering internet streaming television.
Let me ask you this. There's several courts around the country now, both state trial courts and federal trial courts, who have ruled on this precise issue before us, correct?
There are several courts, Your Honor, that you're correct that there are several courts that have addressed various issues. Not all of them have addressed these issues. Some have addressed only the standing issues. Some have addressed these issues. And there are also courts that, in Missouri, for example, and Indiana, that have allowed the cases to proceed past the motions to dismiss and have, while the posture is different because they're deciding whether or not the complaint plausibly alleges whether the statute would apply, the rationale that they apply is the same that we're asking this court to adopt.
Would you agree that the majority, at least the majority of the courts, have ruled in petitioner's favor on these issues?
I don't know that, Your Honor, yes, more courts have ruled in petitioner's favor on these issues, but I would also say that the statutes in those states, although similar, are different. The laws, the state law that was being applied is different, and I don't think this court needs to get there because, again, we believe that the plain language is clear and that the court must apply the plain language of the statute.
So you're taking the, I'm sorry.
No, go ahead.
So you're taking the position that the Tennessee statute is, there are significant differences between the Tennessee statute and the statutes in the other states?
I don't know that there are significant differences, Your Honor, but there are differences. And one difference that I'd be remiss if I didn't point out is that Netflix's counsel pointed multiple times to Section 305E2, which speaks to the construction, maintenance, operation of wireless systems. What Netflix ignores is subsection E1, which separately seeks the provision of video service. So E1 states that the certificate of franchise authority grants, quote, a non-exclusive grant of authority to provide cable or video service in the areas set forth in the application. E2, which is stated separately, provides that a non-exclusive grant of authority to construct, maintain, and operate facilities through, upon, over, and under any public right-of-way. And so if only those entities, if they're correct, that only those entities that construct, own, or operate facilities in the public right-of-way, there would be no need to have a separate grant of authority for the provision of video programming.
So your position is that E1 is a distinct difference between the Tennessee statute and other statutes?
I know, for example, Ohio also speaks to the provision of video service, but it didn't have a separate subsection delineating provision versus construction, maintaining, and operating. And Ohio, of course, has not decided the issue. We just argued it a couple weeks ago. To my knowledge, the only court that has decided the construction issue is the trial court in California, which is currently on appeal. There has been no appellate decision in that case or any of these cases. And so a number of them are currently being appealed. They are being briefed, and there will be decision on those appeals here.
Is the one in Ohio the only one that's been argued? Is it the one further down the pipeline?
The one in Ohio is the only other one than this court that was a certified question to the Supreme Court, and it has been argued. I'm not sure. I know the Nevada case has been briefed. I'm just not quite sure if there's been oral argument on those briefs, but there certainly have been briefs submitted in various appellate court cases.
I'm sorry, can I drag you back to subsection 19 again?
Sure.
Tell me again the particular language that I may have misheard you. I want to understand the particular language in the public internet exception that you are relying on to say that Netflix and Hulu do not fit under that exception.
Yes, Your Honor. Again, I think that the language enables users to access content, information, electronic mail, or other services offered over the public internet.
Okay.
They
So
do.
How is that, what language do you rely on to say that does not fit Netflix?
Well, they don't enable users to access content. They don't enable users to access information. They don't enable users to access electronic mail.
They don't enable users to access content?
They enable users to access, or subscribers to access, video programming, which has its own definition under the Act. And so I would say that if the legislature...
That's the circular, I mean, that seems circular to me because they're saying video programming means like ABC. So they specifically say, we offer content. It's not channelized, it's not, you access it however you want, by satellite or whatever. So how is what they offer not content? Video programming is specifically defined as like a broadcast television station. So that seems circular to me.
Well, if the legislature intended it to apply to sole video programming providers, then I think it would have stated that the service that enables users to access video programming, content,
Video
information...
programming in this is defined as like a broadcast television station.
comparable to broadcast television.
That's right. So content would be different. How is what they offer not content?
Well, I think the term content can be very broad. I mean, anything, information can be content. Video can be content. It could be audio, could be content. But if the legislature intended for video...
You're saying then Netflix and Hulu do not offer content, and that is your argument for saying why this exception does not fit. I mainly want to understand what your argument is based on the language.
Our argument is that video programming, although it may qualify as content, is certainly a much more narrow definition. And if the legislature sought to include...
So in order to hold for you, we would have to find that Netflix and Hulu do not enable end users to access content. Fair? That's the language in the exception. So does that encapsulate your argument?
I think our argument is that if the legislature...
Well, I asked you based on the language.
I don't...
You're interpreting language.
Sure.
So I want to know the language that you're relying on. You said it's the language that enables end users to access content. So your argument related to that language is what they're offering is not content. But if I'm misstating your argument, please correct me. I just want to understand it based on the language.
The other portion of the statute that we're relying on is the word solely as part of.
Where are you seeing the word solely?
I did a word search in the statute for solely, and I didn't find it. So it may be another statutory provision. I'm looking at a definitional.
Yeah, I see as part of, but I do not see solely.
I might have misspoke, Your Honor. I apologize, but I think the other point then is just part of. It's not their video content, if you want to call it video content or if you want to call it video programming, is not part of a service that enables access to any of those types of information listed there.
Okay,
it is
so
the
the language-
entirety of their service. So
that sounds like your argument based on my question was, what language in the exception are you relying on? It sounds like what you're actually saying is that you're relying on the as part of language, that Netflix and Hulu don't offer it as part of a service. They offer it as their entire service, so therefore the exception does not apply.
that's correct, Your Honor, and it's worth noting that is what the Missouri court found when it ruled on the motions to dismiss.
So would it be your position then if, Hulu or Netflix started offering kind of any other thing in addition to video programming, that they would then fall within this exception? Do they need only have, something in addition, even if it's a very minor part of what they offer?
I think you need to look at the structure of the act, which is intended to apply to entities that are in the business of providing video programming, like traditional cable television, like the petitioners. That's the thrust of who this was meant to apply to, because they're the ones competing with the traditional cable providers. They're the ones who are taking away the revenues from the municipalities in the state of Tennessee by directly competing with them. So if, for example, I think they use in the briefs, websites like the New York Times, for example. Well, the New York Times is different because while it may offer short video clips on its app or on its website, it also offers articles, information, crossword puzzles.
Content, right.
Whether it would be information or content, it would certainly be that.
One of those, okay.
But their subscriptions are also partially derived not from video programming, but this other information content services they're offering. So it would be very difficult to delineate which portion of the franchise fee is being derived from video programming versus this other content. We don't have that problem with petitioners. The only thing they provide is video programming. Their subscriptions, you pay the subscription, and 100% of that goes towards video programming, just as if...
Well, they do point out that some users access this content, the video programming, over a smartphone, right, over a wireless network. So how would you, if this act actually does apply to them, would you have to separate out the, I guess, the portion of the revenue that's generated that is attributable to users accessing the content over a wireless network?
So I don't think Knoxville or the municipalities would have to separate that out. The statute puts the burden on the video service provider to calculate the gross revenues that are attributable to video programming. And so they would provide that calculation to the municipalities, and then the municipalities would have the right to dispute that.
But you would say anything attributable to video programming would count regardless of how it's accessed, whether it's accessed through wireline facilities or a wireless network.
So the statute expressly excludes cell phone carriers or cell phone services as well as satellite services. So if they have a subscriber who only accesses content through a satellite or through their phone, which I think through the phones, and this might be beyond the record, but I mean 90% of their services are offered through wireline facilities. But if they had a subscriber who only viewed content via a satellite internet connection, then they would simply exclude the revenue attributable to that subscriber from the calculation of gross revenues.
Can we, I want to, I guess, back up a second and talk about how your interpretation of subsection 19 makes sense in the broader statutory framework. I think I understand, your argument about the plain language of subsection 19, but we're not interpreting that subsection in isolation. I mean, we've got to look at the overall statutory scheme, the statutory context, and interpreting that. And I mean, I have a hard time understanding how your interpretation would not lead to an absurd result where, you've got an entity that does not own or operate any wireline facilities having to obtain a franchise so that they may operate or own, construct a wireline facility in the public right-of-way.
Well, I'd again point to the language in the application process, which doesn't speak to you need to file an application in order to construct, own, or operate. It says offering video service, provision of video service. The state-issued certificate of franchise authority expressly grants a non-exclusive right to both provide video service as well as construct, own, and operate. And so while there are certainly provisions in the statute that speak to the construction, ownership, maintenance of wireline facilities in the public rights of way, I think, for example, Hulu talks about in their reply brief that once you no longer provide video content, or if you're withdrawing, you have the obligation to remove any facilities that you have in the right of way at that point. Well, I don't think that creates an absurd result. I think simply Hulu and Netflix would not need to worry about complying with that particular provision. So in other words, while those statutes do grant authority to own and operate and maintain wireline facilities, they don't mandate that only those entities that own, operate, and maintain wireline facilities are subject to the Act. It's a permissive grant of authority to both provide video service as well as if you need to construct, own, or operate facilities in the right of way in order to provide that service, you can also do that as well. And then, Your Honors, the last point I would like to just address with my brief 1 minute remaining would be video programming. So you asked Hulu whether or not they tacitly concede that they provide video programming, and counsel said, well, we don't think you need to get that far. Well, I submit the reason they tacitly concede that they offer video programming is because they do offer live television that is both channelized and linear, that is indistinguishable in both format, technology used to deliver it, and quality from traditional cable operators and broadcast television. And we believe that Netflix, Your Honor also asked about the definition of programming, and we believe there is more than one definition of programming, as you pointed out, and that their content, because it has reached a level where it is, again, indistinguishable, essentially from broadcast or cable television. I mean, you can access it with a push of a remote on your TV, that they do meet the definition of video programming. And then lastly, I would just point out that Netflix, I think last year, more than doubled the number of Emmy Awards than any other platform in the country. And Emmy Awards
Well, that's mean for you to use that against them now.
That's a good place to stop. Your time is up.
Thank you, Your Honors.
I want to address the question of whether or not other appellate courts have ruled or opined on the language at issue. In terms of the public internet exclusion part, the back half of that definition of video service, absolutely other appellate courts have opined on what that means. The Fifth Circuit, as we cited in our brief, specifically in White Buffalo Ventures at 420 F3rd 366, as well as the Ninth Circuit in Gordon, I don't have the site memorized, but both of those circuits have ruled that that language, which is the same here and in several other states, extends to services beyond ISPs. The Ninth Circuit says it's not limited to ISPs. The Fifth Circuit says it's so broad that it encompasses certainly traditional ISPs, but also email providers and even most.
Which language are you referring to?
So this is the language that's our provision as well that says video programming provided, not video programming part, a service that enables end users to access content, information, electronic mail, or other services. That language.
That's an exception.
Correct. That language has been interpreted by the Fifth Circuit to include most website owners, and it's been interpreted by the Ninth Circuit to go beyond ISPs.
But in all of those cases, was it the case that the entity at issue provided more than just video programming?
Well, those were not video programming cases.
Right, I know. I mean, that seems to be the distinction here. The language, I think as we eventually drilled down on it, it seems to be that the language that's being relied on is really as part of.
Yeah, and so as part of that, the only court that's addressed that so far, Your Honor, squarely, I think, is the California court, or actually the Nevada court also, which said, look, the only statute requires that the programming, any particular piece of programming, be part of a service. It doesn't say that the other content can not be video content. It simply says that as long as what you're getting it is part of a service that enables you to access content, which stays this broad.
Are you talking about the Ninth Circuit or the City of Lancaster case now?
I'm talking about the City of Lancaster case.
Okay.
So like I said, the video programming variation that says as part of, that no appellate court has ruled on yet. You be the first one.
I'd like to talk a little bit about the standing argument and
Yes.
Statutory standing argument, I guess, whether we should address that question. I mean, there doesn't really seem to be a question about our authority to address the issue that was actually certified by the district court in this case. And I think that distinguishes this case from one of the cases on which you relied, where the court initially addressed whether it had authority even to rule on the certified question. So, I mean, to me, the question of whether we can address this depends in part, at least, on whether this statutory standing question would be a threshold issue for the federal court. Do you have any response to that? I guess whether the federal court would need to address this statutory standing question before addressing whether the act actually applies to Netflix and Hulu.
Absolutely. I think from our perspective, we're the ones who raised it. We think certainly, I don't think this court has the inherent authority to sort of answer a certified question. The question is whether or not it should go further and answer the kind of threshold question. I think for the federal court, it has to rule on statutory standing, meaning that there has to be a private right of action. I think it also needs to address the issue of Article 3 standing in that instance, because there has to be a claim for fees. If they don't get to the fees without being a holder, you have the same problem there. Both of those issues, I think, go to the larger question, which is if there's going to be an attempt, despite the consensus of practice and what the TASER report indicated of no one applying this, if there's going to be an expansion of the statute beyond its terms and how it's been applied, that probably should involve the agent with exclusive franchising authority in the state, which is clearly the PUC, not any particular city, because the statute was enacted to take away franchising authority from cities. And it certainly should be, or at the very least, answered by the legislature ultimately in terms of an expansion. I think the line drawing issues that would be presented if this statute applied, even if you don't have wireline facilities, it either turns on quality determinations, such as how many Emmys you win, which is, I don't think, a content-based distinction you should rely on, or it turns on things like, are you a church streaming, or, are you making money? By the way, this statute will require you to pay fees to the state and the department, even if you don't have revenue. The statute isn't limited to a percentage of revenue, even that's what we're focused on. The statute would require anyone providing video programming, whatever we think that content means, including a church, including this court, and it would obligate it to seek prior permission and pay fees to the state, in addition to franchise fees to municipalities. I submit there's a reason why the statute has always been based instead on the bright line. Are you a facilities-based provider? Do you dig up the dirt and put or operate facilities? That's why they said, well, the franchise is permissive. But that's their problem. The franchise is permissive. If we don't need to operate or construct, then you shouldn't be applying the franchise mandate to us in the first place. That's exactly the problem with their claim and their attempt to apply the statute here.
All right. Thank you, Mr. Gee. Thank you all for your arguments. We will be adjourned until in September. We'll be back here in Knoxville. Thank you.